virtually over the Zoom. And we have the attorney for defects, Mr. Scrivonic, their case manager, Mr. Moore. The mother's attorney, Allison Crane, is here. The mother is not here, Anisha Johnson. Um, the guardian ad litem attorney for the two kids, Ms. Miller, is here. The father, Christopher Burns, is not here. Were the kids excused? They're elementary school age, it looks like 5 and 3 or 5 and 4, 6 and 4, something.
I, I'm filling in for Alyssa, and she'd sent me her notes that she'd talked to the maternal grandmother, so she must have excused them.
Is that where they're placed?
Yes, Your Honor.
What's the name of that grandparent?
Taylor.
Say again?
Sean Taylor.
And that's maternal grandmother?
Yes, sir.
And she's not here either. Did she say she couldn't make it?
She has work at 9, so I'm assuming that's why she didn't come.
All right. Where Ms. Strock was just with me at the 8 o'clock hearing. Did
She had a 9 o'clock Superior Court case with Judge Roberts.
Okay. All right. Go ahead, Mr. Scrivani. You want to give me the summary, or you want to let Mr.
No, I'll do it, Your Honor. So I got a court report from Mr. Moore, basically that as far as the case plan goals, the mother and the putative father have completed their domestic violence and parental fitness assessments. The department has not received the results of those back yet. The mother still has not done the competency evaluation that this court ordered. Mr. Moore, I think, stated that it's scheduled for sometime this week. This is, I think, at least the second or third time that we've tried to schedule that, and it's not been done. That is the only progress that was made by the mother, is that she's done those 2 assessments. She has not visited with the children since they came into care. As to the putative father, he was scheduled to undergo DNA testing, but did not show for the scheduled DNA test due to an alleged work conflict on his part. So the department is going to work on trying to get that done. The putative father also has not visited with the children. It is reported to the department that the oldest child is trying to reach out and contact the putative father, but there's not been any regular face-to-face visits between either of the parents and the children at this time. As indicated, Mr. Moore, the children are placed with the maternal grandmother, Ms. Sean Taylor. They're doing well in that placement. They've not got any issues at this time. They are up to date on all of their medical and dental appointments. They're not, children are not receiving any services other than the babies can't wait. That was done for Chloe in December, and then 9 was also referred to babies. Well, I guess I'm confused by this apprentice. It says 9 was referred for babies can't wait due to his age. That doesn't make any sense.
Because he was 3, so he gets baby can't wait, and Chloe did a trauma assessment. Because when they're under the age
Okay, so it was a trauma assessment for Chloe?
Yes.
All right. And were there any recommendations from that?
They both have been recommended to do play therapy, but they're on like a wait list for play therapy because it's hard to find people that actually do play therapy.
Okay. So is the department then looking at trying to find play therapy providers for the children at this time?
Yes, they on the wait list for a provider out of Griffin, but I am still looking for somebody who could possibly go ahead and start.
Okay. Further, Your Honor, Mr. Moore reports as to the mother, Ms. Johnson. She's been, how do I want to put this nicely, very difficult to get in touch with. The same goes for the putative father, Your Honor. I don't know what the deal is with him. He had appeared for I want to say the 10-day hearing on this case, and he hasn't appeared for anything. He didn't appear for the 30-day, and he hasn't appeared for this one. So there's been minimal progress made
Is
by
there some question about where they live, that there was a place that they claimed they were living, but it was uninhabitable or something? Or is that a different different case?
So the dad was living with his mother in an apartment in Stockbridge. The mother was then living in an Airbnb in, I think, Hampton. And then she moved into the sort of friend's home in McDonough, and then she got kicked out of that home. So dad is still with the paternal grandmother to the department's knowledge. Mom is in the wind as far as where she lives. Mr. Moore has had some contact with her about, getting, finding a place to live. She basically taking the position, well, DFAX needs to basically set me up with a place to live. And Mr. Moore is, no, we don't do that, but here are some, services and far as, referrals that can help you try to find housing, because mom basically thinks that, DFAX will pay for an Airbnb for her, and that's not the way that works. So, if that answers the court's question.
They used to have what they called PUP funding, and they would pay a month or two or maybe three of rent, but it was in cases where it was likely to be a short-term removal, and that once they got, but this woman hasn't even visited her kids, so I don't, and she hasn't done the assessment, so I don't know. I don't think the PUP funds called by that name don't exist anymore. If they have other funds to assist people who get stable and are expected to be able to maintain their stability once you help them out, that's another problem that you had, is people, they weren't getting jobs, so they weren't going to be able to take over the rent responsibilities, utilities, or anything once DFAX's money ran dry. So do y'all have anything like that now?
And we tried to help her out like that to prevent removal. But from my understanding from mom, she was skeptical about it because we tried to pay in cash. And she was wondering why we was trying to pay in cash.
She refused it because she thought y'all were pulling something.
Yeah,
Well,
because they tried to pay
she
in
was
cash.
paranoid about being tracked by, people trying to locate her, as far as if she gave like a copy of her ID to the hotel and or using a credit card. So that was, prior to removal, the department tried to work with her with regards to, providing some financial services at that point.
All right. So her lack of progress is not so outrageous that you're ready to move to another permanency plan, but it's minimal at best.
That's correct, Your Honor. I've not received any request at this point for a change in permanency plan. However, I suspect that will be an issue when we come for the permanency review for these children if we're still in the same boat.
Well, it's all puzzling, but if you can't do anything, you could visit.
She said her anxiety is too bad to visit the children.
Say again?
She told me her anxiety is too bad to visit the children.
Okay.
She said once she have to leave the visitation, then she probably will have a meltdown. I'm not sure what that's supposed to mean, but that's what she told me.
Well, I'm speculating in my head, but I'm not gonna say it out loud. Because it could be a number of things. It could be pointing to some significant mental illness. It could be an avoidance mechanism for responsibility and just avoiding things unpleasant, which would be when, it's not going to be any less pleasant the longer she waits to reunite with her kids, if she ever does. It's going to probably be more painful, more uncomfortable the longer she waits, because these kids still remember her, and it probably might want to fuss about it, where she's been. She's not working as far as you know, and you have some concerns about whether she's sufficiently about her faculties to be able to work, maintain employment. Well,
I know the dad reported, Your Honor, that he had some employment. The last thing that I recall from the mom was saying that she was sort of self-employed, doing these kind of what. Prentice, you're shaking your head. What was she doing after that? That was the last thing I remember.
The only income mom reported is she get paid $850 a month by loving her hands or something like that. Some
Yeah, she got some kind of
assisting her.
But she had reported back when we had done like the 10-day hearing that she was self-employed with some business that put contractors in place for Fortune 500 companies, whatever that means. It never was clear.
well, that loving hand sounds like something that's some kind of charity that she's getting a gratuity, like
No,
a
it's
debt subsidy or something.
yeah, it's called something else. She sent it to Ms. Crane, I think, who forwarded it to me. Allison, do you remember what the name of that provider was?
I don't remember. It just seemed very unusual to me, and I didn't really understand who they are. It looks like maybe it is some sort of nonprofit that focuses on women and children, or maybe women and children of color, and they can apply to receive like money. I don't know what they have to do for it though, and they get it for like for like a year or something, and it's supposed to help. I'm not really sure.
And I just looked it up. It's in the order from the 10-day, Your Honor. It was called In Her Hands.
Mhm.
As the provider. And I think that's what Mr. Moore was saying.
Well, every month it's in her hands, $800 and something.
Well,
Well,
that's what the letter says.
it just unfortunately doesn't look like it's promoting or fostering any form of stability on her part, other than giving her some spending money. If she doesn't have a place to live, which is probably what it was for. Maybe she does have a place to live and y'all hadn't figured out where it is. And she hadn't let you know. All right. I'm sorry, did we cut your report over or was that it?
I didn't have anything further to report, Your Honor.
Is all that true and correct, Mr. Moore, that he reported?
Yes, sir.
Anything you want to add?
No, sir.
Any questions from council?
Not for Mr. Moore, Your Honor.
No, sir.
All right. Let's go through my checklist. Children remain dependent. Existing case plan for the time being, at least, appears to remain appropriate. Compliance is minimal at best, but not egregious enough for the department or for the court to seek to change the case plan, the permanency plan. The placement is with maternal grandmother, Miss Taylor, and that placement's appropriate, Mr. Moore.
Yes, sir.
Is she not able to cajole her daughter into at least coming by to see the kids? Or is she in a strained relationship with her daughter?
Yes, it's a different relationship.
Like no relationship?
You know, the mother of the kids at the last hearing was saying that her mom
Wanted him to go to foster care and not her mother.
right, because she was saying her mother wasn't her mother. She repeated that a few times
Because she adopted her or because of something else?
because of mental health.
Oh, because her mother had abandoned her or given
No,
up on her?
no, sir. It's just because of It's just because of Ms. Johnson's mental health.
Okay. All right. Um, far as I can tell, there are no legally required services that aren't being afforded the parties. Visitation's not appropriate because it's not going, but it's not because of the department. It's because the parents not participating. Nobody's over 14. Reasonable efforts have been made initially to avoid removal and are being made to facilitate permanency. And we're not gonna, and the department currently is not planning to terminate parental rights, but may seek a change in permanency plan if the parents don't up their level of compliance. Anything else I need to cover?
I just need to ask Mr. Moore, Prentice, when is the mom's competency eval scheduled with Dr. Gothard's office again?
It's February 19th at 10 o'clock.
February 19th?
At 10 o'clock.
Does she require transportation to get there?
Yes, sir. We have been working on transport for her, but it'll be difficult if she don't tell us where we can pick her up from.
Yeah. Maybe that's an unpleasant discussion that she prefers to never do today what she can put off till whenever. That it'd be like confronting your demons if there is if she at least acknowledges or recognizes that she's got some intellectual deficits, emotional deficits, or combination that make her questionable in terms of being able to function.
It could very well be too, Your Honor, if you'll recall, the mother and grandmother, I think, testified that she'd been trying, or there was some information about concerns that the mom may actually have an underlying medical condition that may be impacting her, and that she'd been trying to get her to follow up with medical providers, and mom was refusing to do that.
Yeah. Okay.
Your Honor, I'm sorry. The only question, I just want to make sure I'm still not fired. Is that?
Yes.
She fires me every time I talk to her, so I just want to make sure.
Yes.
Okay.
The relative search reports, I'm glad I thumbed to the front of the file or on front. I don't look, well, it didn't look like we ever circulated. Well, you just filed them Friday. Mr. Moore, when was the deadline?
You know, at the last hearing, you told me I had until today.
Oh, did I?
Yes, sir.
You must have pulled one over on me. My
Maybe
God,
you're in a good mood.
aren't I always in a good mood?
Mm,
Aren't I almost always in a good mood?
yes, sir.
Well, let's see. Other than maternal grandmother, did you find anybody else? Let me guess, the parents wouldn't tell you anybody else. And I remember talking to Dad about him giving you people.
No, sir. Dad reported that he only had the people in his house,
Yeah.
and that's him and his mother.
Well, I don't see her name on here.
He didn't give me any information for him.
Oh. Well, did you ask him? He said, the
Yes,
judge
sir.
told you had to give it to me.
Yes, sir. I asked him. That was the same day I asked him about the DNA test.
And what did he say?
He said he was going to text it to me, and I never did receive the text. The next info I got from him was him not showing up for the DNA test.
All right. Well, the court approves the diligent search report filed February 9th and will require you to supplement it periodically as required by law and to continue to search for relatives, even though we have an appropriate relative right now who's placement resource, and that's good. I don't know why they can't have it in the statute that if you've got it, if you're using a relative, why you have to keep looking, because, I would think those, not that I think you've been turning over too many stones looking, but you know, what efforts you do try could be spent doing something that's more important to the case. Now, we have had the misfortune of having a relative placement that suddenly no longer became either they got tired and quit, or problems arose that needed to move. And then, you know, if you've got that backup list, it kind of makes it easier. But it doesn't sound like there are going to be many people in this one. But follow up with Dad and see if you can get him to do it. That's about all you can do. And
Yes, sir.
if he ever shows up, you can remind me to bug him myself. Okay?
Yes, sir.
Be sure to include that it's approved. And the 9-month permanency review will be March 18th.
No, that's the initial judicial review, the 4 month. We already set the 9 months back in the 10-day hearing,
So this is 4 months from when?
the date of removal. It says we're supposed to come back 4 months after the date of removal after the 75 day.
I thought we were supposed to, well, whatever. March 18th at 11 o'clock on Zoom.
What month was that? I'm sorry, I got the 18th.
March 18 at 11 on Zoom. That's the initial judicial review.
Okie dokie.
Hold on a second.
I have a question.
Yes, sir.
Did they change the review dates from the 6 month that we used to do?
I don't know. I'm just going by, Jessica said it's 4 months from removal. I thought it was 6 months from removal, but
Initial review is 4 months from the date of removal.
she says there's an initial review 4 months after. So we're going to have reviewed this to death. So we'll see you in March, and then I'll see you again in August. Okay?
Yes,
All
sir.
right.
Thank
Thank
you.
y'all.
Thank you.
Have a good day.